And we are live, Senators.
All right, good morning. This is Senate Health and Welfare. It is February 17th, and this morning we're going to begin by looking at S37. It's an act relating to access to legally protected health care and activity and regulation of healthcare providers. And we've been working on this one for a bit. We do have our alleged counsel with us to go through some possible changes to the draft as it was introduced. So I'm going to start with that. And I don't know who, Jen and Amber, do you want to be together?
I think if we're starting with my sections, I think I'll start.
Okay.
Jen,
Let's do it
join
together. Do you want us to? I don't care.
Okay.
It's up to you. So you each have a hard copy. I think it's easier to write comments on it at this stage of the game. If you, as we go through the bill, Amber, that would be helpful for us to know, the changes that have been made. Then there are places where there's been a huddle out in the hallway, some discussion outside that would help us. So we'll hear, who the folks were that were involved. I will say, I did spend some time with Jen and Amber, as I said earlier in the week, going through some of the comments that we heard in committee and made some recommendations based on input from various sources. So here we are. So why don't we go ahead?
All right, for the record, Amber Navigili, Legislative Counsel. Let me take a moment and share my screen so people can see the draft language that we're looking at. Perfect. So in front of you, we have draft number 1.3 for S37, a markup version. This is a strike all. Has this committee seen a strike all amendment? Yes. Okay. So just an overview on how to understand all of the edits that we've made in here. Everything that has been changed from the original S37 is introduced is in yellow. If it's a strike through, it's language that we're removing from the as introduced version, and then new language is bolded and highlighted. So the first change is in section 1 in the definition section, specifically around gender affirming healthcare services, with the addition of the words and gender incongruence, following gender dysphoria within the definition of gender affirming healthcare services. This was a recommendation in written testimony, both from the Department of Vermont Health Access Medicaid, as well as from the Vermont Medical Society, to cover more areas of care.
Okay, as we're going through, if anyone has a concern, just raise that concern so we can talk about it. If we're all in agreement, we'll just keep moving through. So I'm not hearing anyone say that in disagreement about this. So, expert opinion.
Looking at subsection B, which is the definition of legally protected healthcare activity, toward the bottom of page 1, and going into page 2 and on to page 3. You'll recall Michelle Childs went through H89 with you the other day, and I mentioned that we were looking to put the definition of legally protected healthcare activity from that bill into this bill. So some of the language you see here in yellow, the changes are from moving that definition from H89 into this bill. However, I have made some further changes in response to some comments on the House floor during the H89 floor discussion about how use of the word insurance within this definition of legally protected healthcare was perhaps unclear as to the intent. So see, what I've done is also untangle the insurance piece from the healthcare provider piece. So having said all that, in subdivision A, You'll see some strike through language at the bottom. This is where I'm removing references to insurance coverage for services. And then I'm going to, moving on to page 2, I'm going to read how this definition will read if all these changes are made. So this would constitute legally protected healthcare activity. Any act or omission undertaken to aid or encourage or attempt to aid or encourage any person in the exercise and enjoyment or attempted exercise and enjoyment of rights to reproductive healthcare services or gender affirming healthcare services secured by this state, provided that the provision of such a healthcare service by a person duly licensed under the laws of this state and physically present in this state shall be considered legally protected if the service is permitted under the laws of this state, regardless of the patient's location.
So well, keep going, and then I'm gonna come back to one phrase.
4, and now subdivision C is the new language that I have added that was not in H89 to address the insurance piece. So legally protected healthcare would also mean the provision, issuance, or use of, or enrollment in insurance or other health coverage for reproductive healthcare services or gender affirming healthcare services secured by the state, or any act to aid or encourage or attempt to aid or encourage any person in the provision, issuance, or use of, or enrollment in insurance or other healthcare coverage for their services, regardless of the location of the insured or individual seeking insurance or health coverage, if the insurance or health coverage is permitted under the laws of this state. I will pause there for a moment, because next we're going to move into some clarifications about those.
Can I just ask a question? Basically, is it okay, Chair?
You'll get ahead.
Okay. The basically what it seems like you did was split out the whole conversation of insurance to a separate subsection,
Yes.
so that it's
Yes.
more clear. Okay.
Yes.
That was how I was reading it. Just want to make sure.
I have a question. So in line 12, healthcare services secured by the state, what is that? How would it?
So reproductive health care is protected under statute and also now by our Constitution. And then we are adding within our statute with this bill required coverage of both abortion-related services as well as gender-affirming healthcare services. So that's what's intended by that phrase. But if that is not clear, I'm open to revising.
Is there a better way to express it?
I can try and think of one.
Yeah, okay.
The word secured.
Secure is a difficult word.
Yeah.
Yeah.
Yeah. Protected by, well, I don't know.
Protected.
Who knows? You know, I'll let the legal.
Yeah. Thank you.
Yeah.
You're
so-
welcome.
Question I have is, I know we've been getting a lot of emails and we've heard testimony about telemedicine and telehealth. And so this explicitly indicates a physically present in the state on line 7. So at this point, we're talking about patients who are physically present in the state. What are we saying?
No, in this section, we're talking about a healthcare service provided by a person, a
Who is
provider
physically present.
who is physically present in the state, but regardless of the patient's location.
Okay, so when we get to discussion of telemedicine, telehealth, we'll have that broader discussion.
Subdivision 2 at the bottom of page 2. Except as provided in subdivision 3 of this subsection B, the protections applicable to legally protected healthcare activity shall not apply to a lawsuit, judgment, or civil, criminal, or administrative action that is based on conduct for which an action would exist under the laws of this state if the course of conduct that forms the basis for liability had occurred in this state. So if I could phrase that in a different way. So as we have made these protections in the previous subdivisions, what we're saying in subdivision 2 is that the protected activity is not going to include a lawsuit or a judgment or a civil or criminal or administrative action. That's based on conduct that if the provider had done that in Vermont would not have been legal in Vermont. So that's what we're saying here, to make sure that we're not we're not overly protecting conduct that wouldn't have been legal in this state.
Questions there? We good? Okay.
And then, as an exception to what I just read to you, subdivision 3, notwithstanding subdivision 2 of this subsection B, the provision of a healthcare service by a person duly licensed under the laws of this state and physically present in this state shall be legally protected if the services
If the service is prevented.
Oh, it's a service. Thank you. It's my reading, not the word. Okay. If the service is permitted under the laws of the state, regardless of the patient's location, or whether the healthcare provider is licensed in the state where the patient is located at the time the service is rendered. So in this instance, normally under Vermont law, a provider could be disciplined for providing services without a license in the state, to someone in the state without a license in the state. So in this instance, we're saying it will still be legally protected healthcare activity if the service is permitted under the laws of the state, and regardless of whether the healthcare provider is licensed in another state. So this is another aspect of the telehealth services. So under this new language, which comes from H89, if the provider is physically present in Vermont and is licensed in Vermont, but is providing telehealth services to a person in another state, and the provider is not licensed in that other state, that would still be considered legally protected healthcare activity. You may recall when we went through S37 initially, there was a question about what that language said about the situation of telehealth. And there was a discussion in House Judiciary on H89 about whether it was clear, whether this licensure issue was clear. And it was determined that maybe it wasn't very clear. So this language clarifies very clearly what we mean.
Questions here? So in a practical sense, this means that if a physician is licensed here in the state and the patient's out of state, they can provide continuing care via telehealth. That's important for us to understand.
Right. Switching topics, moving into medical malpractice insurance. You'll see on page 5.
Can I ask a quick question? Sorry.
Yeah, let's do that. I mean, if you have questions,
Yeah,
please ask.
I don't want to muddy the waters, but we did have that long discussion of compact.
We're not there yet.
Okay,
But so hold that until we get to that section of the bill. As we go through the bill, focus right where we are, and then
Gotcha.
when we get there.
okay.
And that you're probably thinking of that because of the.
Yeah.
Yeah.
Madam Chair,
Sure.
trying to catch up.
Yeah.
Just a question. So I fully recognize that abortion state constitutional amendment. I fully respect that. My question is in regards to gender affirming care. I just want to ask: is there a previous law that protects that legally protected healthcare activity, gender affirming care, and all the definitions that exist within this bill? Is that already precedent? Is that just like the amendment gave precedent to the abortion services?
We do have, Cameron, you want to respond to that? Because we did pass a very strong resolution last year. And
We have a resolution.
Yeah.
I'm not sure that we have any language
I don't
in
know.
statute that's
trying to remember
comparable
statute.
to the reproductive health care.
We have
statute.
anti-discrimination.
No, I'm not asking about reproductive.
Right, I'm saying,
I
I don't
understand.
think we have anything comparable to what we have for abortion or reproductive health care. Language for gender affirming health care services.
So in this 18 VSA 8351, that doesn't articulate that this is a previously legally protected healthcare activity. I'm just looking for precedent.
No, 8351 is actually the definition of conversion therapy. This is specifying the gender affirming healthcare does
Right.
not include conversion therapy. So we do have some,
That was a huge discussion.
Jen Kirby, legislative council, we do have some insurance, general insurance provisions and a bulletin from the Department of Financial Regulation on gender affirming care, but we do not have the same kind of protections, as Amber said, in place for gender affirming care that are in place for reproductive health care.
Okay. Thank
This would create some of that.
And I would just add that there are other states that are doing this type of law are including both. That's Massachusetts that passed their law last year, including both, largely because of the things that are happening in other states related to gender affirming care.
Go ahead. So where are we then? Page
Now-
4?
I moved
Yeah.
into the medical malpractice in section 2, moved through. There are no changes to the definitions for medical malpractice here. And then on page 5, I have done some bit of reformatting for subdivisions here. I removed, so let me read F here. Discriminating against a healthcare provider as defined by 18 VSA 9496 or adjusting or otherwise calculating a healthcare provider's risk classification or premium charges on the basis that, as I have said, this is, yeah, let me back a little bit. So I'm on page 5.
Okay.
So we're under the unfair discrimination, arbitrary underwriting, subdivision 7. So we're talking about what would be saying that it is unfair discrimination or arbitrary underwriting action to make or permit any unfair discrimination between insureds of the same class and equal risk in the rates charged for any contract of insurance or in the dividends or other benefits payable thereon or in any other of the terms and conditions of such contracts. So now we've with S37, we have added this new subdivision F, saying that it would be unfair discrimination or an arbitrary underwriting action to discriminate against a healthcare provider for adjusting or otherwise calculating a healthcare provider's risk classification or premium charges on the basis that, first, the healthcare provider provides or assists in the provision of legally protected healthcare activity. I removed in this state in recognition of the telehealth aspect that is lawful in another state. 2, another state's laws create potential or actual liability for that activity. 3, abusive litigation against a provider concerning legally protected healthcare activity resulted in a judgment against the provider. Or 4, and this is 4 on the top of page 6, is language that was suggested by Planned Parenthood New England in their written testimony. The license of the provider has been disciplined in any way by another state based solely on the provider's provision of legally protected healthcare activity. I'm going to,
As defined.
yes,
So do
Yes,
we
the
need to
definition
reference that?
we don't because
Okay.
we added a definition
Okay,
to
Yep.
this chapter
that's
to define that term. So where it's used. We'll read. Then there's also a new subdivision 2. You recall we had written testimony from Jamie Feehan on behalf of a client requesting to add the word solely to this provision, and there were some concerns raised in committee about that. This is the follow-up language I received from him. I have blacklisted it because I have follow-up questions for him that we weren't able to connect on. Primarily, so I will read the language as it is. For purposes of this subdivision F, it shall not be unfairly discriminatory nor an arbitrary underwriting action against a healthcare provider if the risk classifications, premium charges, or other underwriting considerations are based on the healthcare provider's claims loss experience or based on an underwriting or rate setting criteria related to practices that do not meet the applicable professional standards of care in the provision of legally protected healthcare services. And so the reason,
That's all right.
I get it. Good.
so this is the reason I put this one phrase in red when we're talking about claims loss experience. Because one of the protections is about abusive litigation, we have said that it won't be on the previous page, on page 5, that it will not, that it would not be permitted under this section to adjust or otherwise calculate the provider's risk classification or premium charges on the basis that there's been abusive litigation against the provider that resulted in a judgment against the provider. But there are varying degrees of what happens during those litigations. There are settlements, which are not judgments. So I don't believe those would be covered by this protection. And if you add the claims loss experience, as they have suggested, I'm wondering whether a settlement, if a provider has one or more abusive lawsuits filed against them and there are settlements, would those be calculated as claims losses, in which case it would be an exception from the protection as the language is drafted here. So all of that to say that I have some follow-up questions because I wanted to confirm that it's the committee's intent that we would want to cover those in areas of settlements not resulting in changes in premiums. Having it limited to judgments is a smaller category.
You good with this?
Go ahead.
I think I need to think about it more, given everything that Amber
That's
just
okay.
said.
So the question is, did Jamie Fian, I think, was the representative here, he hasn't
Yes.
seen this yet, or
This is the language that he provided,
he provided?
yes, as a follow-up to when I
Yes,
said I'm looking to do something alternative to using the word solely.
Yeah,
okay, does it express what the question, or respond to the question, I think, that Senator Hardy was asking the other day? You know.
it might be, but I feel like I need to read it a couple more times and.
Well, yes, okay, so just put a little flag next to that. And when we come back to it next week, we'll make sure that, other folks will be weighing in on this as well. So we'll hold that. Okay, good. Okay.
We're ready to move on to a different topic. Next is insurance coverage. Section 3 on page 6. First is coverage for gender affirming healthcare services. Made no changes to the definitions in subsection A. Subsection B, coverage, has changed significantly since you saw the S37 as introduced. This is language in response to some feedback from the Department of Vermont Health Access, and was, I believe, also reviewed or collaborated with at least Blue Cross Blue Shield. I have sent this to the insurers as well as the Department of Vermont Health Access last night to take a look. So with these changes, and I would say part of the concern is that the as introduced version of S37 has gender affirming healthcare services, and it did not specify anything further than what those services were or what the scope of the coverage would be. So it just defaulted to the basic definition of gender affirming healthcare services, which, as you know, is very broad, right? From all treatments and things for gender dysphoria and gender incongruence. So the request from Vermont Medicaid was to clarify in here, either in the definition section or in this section, exactly what the coverage would be. Yes.
Yeah, so I see the language in here about, so health insurance plans shall provide coverage for gender affirming care services. That, and
Yes.
going down to C, the recommendations and guidelines issued by the World Professional Association of Transgender Health. No idea who those guys are. It's not governmental, just a little.
Before we get further, why don't I read through the language
Okay.
so that we can all be in the same place. So this would break out of subdivision 1, a health insurance plan shall provide coverage for gender affirming healthcare services that A, are medically necessary and clinically appropriate for the individual's diagnosis or health condition. B, are included in the state's essential health benefits benchmark plan. And C, that meet generally accepted practice standards, such as recommendations and guidelines issued by the World Professional Association for Transgender Health, its successor, or a comparable organization identified by the Department of Financial Regulation. I would pause.
So when you talk about a professional association like this, it would be like saying the ophthalmological association, professional group who are versed and experts in the area of care. So in the case of ophthalmology, it's eyes. In the case of transgender health, it's gender dysphoria or other aspects of transgender health. I mean, is that?
C, or 1, that's 1A, medically necessary. I asked that question last time. We said wait till we get to the markup. So I want to know what's medically necessary.
Okay. I'm going to look to Jessica Barnard. Do you want to talk about that from the perspective of Vermont Medical Society, or would you like someone else to?
Jessica Barnard, Vermont Medical Society. No, I actually think it's almost more appropriate perhaps for the insurers to address that, because that's really
that is true.
sort of a term of art in the insurance world as opposed to just anything. So I don't know if.
I know.
And for the record.
I'm Claire Buckley. I work with MVP. I've been a lobbyist for a long time, but new to working for MVP this year.
Yes.
So I guess I know that Sarah Teachout is on the thing, and if I don't know if I could defer to her to give a better answer. I mean, medically necessary is usually, and I would.
And Sarah, Sarah is on Zoom,
Yeah.
right? So Sarah, are you
She's
available to
usually-
comment on medically necessary?
I am, sure.
Terrific.
So it's things like we would look to see if their doctor has determined that they've had whatever is necessary before they decide to seek treatment. So it would be perhaps mental health care, perhaps a diagnosis, that type of thing is what we would look for. And then whatever the doctor's recommendations are for, appropriate medical coverage.
So is that before the surgery or the treatment or after?
So I'm not an expert, I'll say right away, in gender dysphoria, but I think there are recommendations like the person should live as, whichever gender they're choosing, live that way for a certain period of time before they go through surgical changes or take certain prescription medications for a period of time. So there's sort of standard accepted I think, approach so that everyone's comfortable with the process. So we follow.
From the insurance perspective, you'd be looking to see that all the clinical diagnostic information is there, that the work has been done to understand that this actually is a medically necessary treatment for the individual.
You said it better than I did, Senator Lyon.
Senator Hardy wanted to.
I think if we're gonna talk about clinically appropriate, medically necessary care, we should actually have Erica
Dr. Gibson.
back in. It's really complex. And I'm a little uncomfortable with this conversation without a medical provider in the room. And she would be able to explain extremely well what is medically necessary, what is clinically appropriate, and what is within the scope of practice for a pediatrician or a primary care provider when it comes to gender affirming care. There are standards that doctors follow to provide any kind of care, whether it's, cardiac care or obstetric care or gender affirming care. And it is based on their specialty and their, the sort of standards of care in that area. And I'd rather that we talk about it with her in the room rather.
So, but look at the next letters. Look at letter C, because C actually gets to exactly what you're talking about, utilizing the guidelines such as. And so if you would like, we can reach out. I did reach out to Dr. Gibson around incongruence and gender affirming care. So we could reach out to her and ask her for her. I think that A is a more general definition. I'm not sure, but
I think
we
she
can
provided
ask
some
her for a
information.
definition on this. I don't know if we have to, I don't know what her time is like, that's all I'm saying. We can get her back in, we will.
I guess my question is, if we're talking about it, where can we go to find out what it is? And do we need to have some language about what it is in here?
Did you read Dr. Gibson's
No.
testimony? I would recommend that you read her testimony.
Yeah, so start with that, and then we'll reach out to her, and whether or not we need a more, we need a broader definition of medically necessary and clinically appropriate. We go through this a lot in here. Because it, so, go ahead, Ameren, and then Jessa, I think you wanted.
I will also say, medically necessary is a concept and a term of art that's used very
Yes.
extensively for Vermont Medicaid.
Yes,
So it might be helpful to hear from Vermont Medicaid either as a written follow-up or.
Ginger is here. Can you respond to that?
Susan Irish, Director of Communications and Legislative Affairs for the Department of Vermont Health Access, which manages the Medicaid program. Excuse me, in Vermont. So one of the pieces we flagged in previous testimony is that there are certain restrictions around what Medicaid can provide. So we're unable to provide cosmetic surgery. And that's in part because wouldn't be deemed medically necessary. So one of our suggestions was to include this language so that we're able to continue to comply with federal requirements for the Medicaid program and the services that we're able to cover and pay for.
And as Ameren has indicated, it is a term of art within the insurance world, so that sort of confirms it. Okay. So, yes.
If I may, thank you, Jessa Barnard with the Vermont Medical Society. We did send this section actually last night to Dr. Gibson to take a look at. I do want to sort of make that distinction between clinical guidelines and then insurance coverage, because this is really saying that the insurer could determine what's medically necessarily and clinically appropriate for the purposes of insurance coverage, not sort of in the world at large. And the main question I wanted Erica to look at is actually the C piece about the practice standards. That's not typical in our insurance mandate language. And I, maybe for different reasons, actually do have a little concern with putting a specific organization in here or having Department of Financial Regulation identify practice standards. I don't really think that's my understanding, typically the role of DFR. You know, they may give guidance for, again, insurance coverage, but not what's generally accepted practice standards. So I did want her to look at that. I do have a little concern about C being.
Oh, so why don't we circle around, and why don't we ask for you along with, to stay connected with Ameren, and we'll try to get some language that satisfies. Not gonna be easy. That'd be good. Thank you. Okay. All right, so this is another little flag that we have up, because we would like it to be a standard of professional practice, not necessarily evaluated solely by insurance companies. And I use the word solely.
Yeah, I have concerns about the language on page 8 as well.
Okay,
So subdivision 2 at the bottom of page 7, moving into page 8, coverage provided pursuant to this section. A may be subject to a prior authorization requirement under the health insurance plan concerning the amount, frequency, and duration of treatment. And B, for commercial health insurance plans, shall be provided in compliance with rules and guidance issued by the Department of Financial Regulation regarding gender affirming healthcare services. And C, for Medicaid or any other public health care assistance program, shall comply with all federal requirements imposed by the Centers for Medicare and Medicaid Services.
I think this has the same question that Jessa, you were asking about DFR and their role in this. Do we add in any other, or like Department of Health or Board of Medical Practice or OPR? I don't know how to deal with having DFR in charge of making these decisions?
In this instance, DFR is not making a decision, but
They're
is,
issuing the guidance.
to the extent they have guidance on this topic, which at the moment they do, they have bulletin. Number
I know, it's pretty good.
74. So this was done in recognition of that. But that's not to say that insurers can already be complying with
Right.
rules and regulations that are issued by the Department of Financial Regulation. It was more of a flag of notifying, I would say, people that there are already rules and guidance on this topic from the Department of Financial Regulation.
Okay.
What, under subdivision A, what is the health insurance plan? Who is that referring to? Is that referring to Medicaid or any health insurance?
That
plan?
is one of the defined terms, so it means Medicaid and any other public healthcare assistance program, any individual or group health insurance policy, any insurance plan that's under our regulatory.
I'm just concerned that this whole section and the added language is actually negating the protections that we're providing for gender affirming care, because health insurance plans will just be able to deny care.
That's what we're trying to get at.
This is language that was requested by the Department of Vermont Health Access. As background, I think prior authorizations are a tool that is used in healthcare. Whether it's appropriate in this circumstance is not a question I can answer, but
Yeah,
certainly a question that you could look into with.
Prior authorizations are often used to deny care, and I'm really concerned that this is just setting up a scenario where, because Medicaid is concerned, it's just going to lead to other health insurance providers denying care, saying, well, this isn't prior authorized care, or, whatever, that it's concerning to me. It's adding another level of complexity to access this care. Whereas we were very clear before that was covered and required to be covered.
How explicit do we need to be is the question. If we're saying that every health insurance plan shall cover, then though there are also rules that come to us from Medicaid that would have, this is like putting a Medicaid rule into statute, it feels like.
Medicaid is not the only
I know.
insurance companies
I'll
also
use
use.
it as an example.
Yes.
Okay, so another insurance company, by putting these rules in place, it's in statute. So it says you can, you may have prior authorization, and I do agree with Senator Hurry that is sometimes problematic for providers. So this is another place where I put a little flag up. So this is the first time we've seen the language. We have lots of questions, and we're gonna try and seek out some clarification.
Yeah, I mean, it seems like it's making it even harder than current law.
So Ginger.
Yeah, so just want to be clear that I'm not a clinician nor an attorney, but prior authorizations are often put in place to protect patient safety. And that's a tool that could be used to confirm that a patient has had the time living as the gender they're hoping to have surgery for, and that it's generally a tool that's used to make sure that things are clinically appropriate.
They're often used to deny coverage that has been approved
my God.
by a medical provider as well. So I think that it's, all well and good to describe them as protecting patients, but they are often used to deny coverage to
We
patients.
get that, we got it. So I got Sarah Teachout has her hand up.
Thank you. This describes exactly what's happening currently. We follow so gender affirming care is included in the essential health benefits as an already required in Vermont law to be covered. We follow the DFR bulletin, which further describes how we have to cover it. And I think if you talk, I can get a number of patients or family members to speak to you that while we do have prior authorization, I don't believe it's been a significant hurdle to anyone receiving the care that they require.
Okay,
Can I ask Sarah a question?
go ahead.
Sarah, for other types of care, we don't have it explicitly laid out in statute like this, do we? I mean, maybe that's a question for Amrit, but this seems just more explicitly laying out the prior authorization and all of the hurdles for health insurance for one type of care.
I think we did it also on the hearing aid bill, and it's just been a kind of a new drafting approach, but Amarin can answer that.
I would need to look into where else we might have it in the statutes. I don't know that off the top of my head. This language was at the request of Vermont Medicaid, so it was not something that I proactively put in as a standard course of drafting, but that's not to say that it's not elsewhere in statute.
Yeah, I guess I would just be curious if this is more standard for other types of care, and maybe we did something similar for hearing aids. I don't remember exactly. I'm just concerned that we're calling it out in this case and we don't call it out in other cases, and it would end up doing the opposite of what our intention is, which is to specifically protect this type of care.
So, and Amarin is gonna follow up with that one for us, and then Ginger, you want to comment?
Just wanted to clarify that Vermont Medicaid and Blue Cross partner in this language. So Sarah, just, I believe we work together. Just wanted to ensure that folks understood that.
Okay, thank you. Go ahead.
Yes, ma'am. I'm still wrestling a little bit with necessity versus cosmetic, and what I'd like to recommend when Dr. Gibson comes in, that she be sensitized to dealing with that, briefing us on that distinction. I just need to feel a little more comfortable about how the medical community separates the two. That's all.
Okay, well, we'll see if we can get Dr. Gibson in.
Or in testimony.
Yeah, or something in writing, because I did reach out to her and she is really busy. She's got a wait list a mile long. So what we'll do is we'll see if she did respond. So we'll see if we can get her in, and then we'll have her.
Or another commission.
And I'll have Alex reach out to her center, so it'll be good. We'll get her.
No, I'm just looking to see what she already.
I think she already did.
supplied. I
Yeah.
think she already testified.
I am going to go back and look at her testimony.
Let's do that, and I'll do that, and then we'll, and Amarin can help perhaps with that as well.
Jessica Barnard with the Vermont Medical Society. I also am not sure she would be able to weigh in very specifically on surgical procedures, since she is largely treating youth and adolescents, and that's probably more of an adult medicine issue. So we may need to think about that if there's another witness.
Is there a distinction between youth and adults?
Yes.
Very much so,
Yes.
yeah.
Yes, typically there's no surgical intervention until 18, maybe potentially an older 17-year-old, but that's really not until individuals are adults.
Do you have someone that we could reach out to?
I have somebody I have in mind.
Okay.
But again, I want to be clear that that's really a distinction in this case being made by the insurance companies, not necessarily a medical provider. So they may I don't know if they have policies distinguishing which procedures they do or do not cover under those two definitions.
Yeah. Okay. So Sarah Teachout and Claire Buckley and Ginger Irish, from the insurance perspective, you've heard the questions. And we're looking for some clarification that will help us, and we're reaching out to the medical community so we can get clarification from that side of the world. Okay, so we have phoned several friends in this case. Terrific. And we'll go back and look at Dr. Gibson's testimony to see what further our interests are. That's good. Thank you. All right.
Moving on to subdivision 3. Nothing in this section shall prohibit a health insurance plan from providing greater coverage for gender affirming healthcare services than is required under this section. And part of the reason for putting this in is that we do have a narrower, well, I should say, we have a more regulated segment of the insurance coverage here, because we have Vermont Medicaid, which is regulated by the federal government, as well as the state. And then we also have the small group and individual markets on the exchange, which have other further requirements. But then lastly, we do have a very small, large group insurance market, fully insured large group insurance market. So wanted to make sure that this section was not read to limit insurance coverage for these services if there's types of insurance that could provide greater coverage. And then in subsection C, cost sharing. See, I have stricken the language, the coverage required by the section shall not be subject to any co-payment, deductible, co-insurance, or other cost sharing requirement or additional charge, and instead replace it with a health insurance plan shall not impose greater co-insurance, co-payment, deductible, or other cost sharing requirements for coverage for gender affirming healthcare services than apply to the diagnosis and treatment for any other physical or mental condition under the plan.
I think this said law. Okay. It's about insurance, and we received information both from MVP and from Blue Cross and Blue Shield. We've heard consistently from DEVA. We know what Medicaid's about, but the health plans are all over the place, trying to determine what co-pays exist out there and what we can put in a statute is difficult. Problematic, I guess, is a better word. All right, so unless I hear questions there, I think we'll just keep that and then move ahead. So we're keeping 3 and we're keeping C, and we're keeping big C, and we have some questions regarding A and B. And we have questions over on the earlier page. That's 2 A and B, and then with 1 trying to sort that out. Okay. This was the complex part of the bill, one of the complex parts of the bill, so it's important to work it over a little bit. Okay.
Moving into the next section, section 4 at the bottom of page 8, moving into page 9. This is coverage for abortion and abortion-related services. I only made changes in subsections B and C here. I added the phrase subject to requirements under federal law. A health insurance plan shall provide coverage for abortion and abortion-related care. I believe you heard during testimony that there are certain payment type requirements that the insurers have to work through because of the federal government not allowing federal funds to be used for abortion except in limited circumstances. And then Medicaid also has some limits in how they have to, for the same reasons, really, federal funding of abortion is limited. So
I understand that Medicaid has to jump through some hoops because of federal law, but I just want to be clear that this doesn't allow them to not provide coverage for abortion under state law.
Doesn't allow them to.
I want to make sure they still are providing coverage for abortion, and that the subject to federal law doesn't give them an out to say, federal law doesn't allow us to do this, so we're not going to do it anymore.
no, to do that, that would be to the extent required under federal law. Or I think this language works for your purpose, that we're saying the health insurance plan shall provide coverage for these services, but subject to any requirements under federal law. But I could be more.
But if the requirements under federal law are saying you can't provide coverage to abortion,
It's
couldn't
not that
they
you can't
just
provide
say?
coverage, it's that you can't use federal funding to pay for certain types of abortions.
Okay.
Ginger.
I'm happy to add some clarity there, if that's helpful.
Yeah.
So the Hyde Amendment prohibits federal funds for, except in the case of rape, incest, or protect the health of the mother. So Medicaid uses just general fund dollars for other abortions. So from the patient perspective, it's seamless. You're able to access abortion care. It's just where the money comes from because we're not able to draw down a federal match for abortions that are prohibited by the Hyde Amendment.
No, I understand that. I'm well aware of that. But what I'm concerned about is that sometime in the future, Medicaid might say, well, the Hyde Amendment says we can't provide any abortion coverage for other types of abortion. And so therefore, we're just not gonna do it. I realize that now they use the general fund to do it, but would this potentially give them an out to say sometime in the future, oh, we're not gonna provide coverage because the federal regulations don't allow us to?
I'll look at this again. I don't think so, but I will let me find this for myself to think about
Okay.
further.
Okay, so until and unless we hear from you, this is okay.
Section 5, state plan amendments, there were no changes.
Yeah.
Section 6, professional regulation. I have sent this to the Office of Professional Regulation and the Board of Medical Practice. I don't know if they've had time to fully review this, so I will just put that out there before I start. So I have condensed the sections and tried to clarify a bit in here. So first section, which is section 6, is for professions that are governed by, regulated by the Office of Professional Regulation. So it would now read, subsection F, healthcare providers. Notwithstanding subsection E of this section or any other law to the contrary, no healthcare provider shall be subject to professional disciplinary action by a board or the director, nor shall a board or the director take adverse action on an application for certification, registration, or licensure of a qualified healthcare provider based solely on, 1, the healthcare provider providing or assisting in the provision of legally protected healthcare activity, or 2, a criminal or civil action or disciplinary action against the provider by a licensing board of another state based solely on the provider providing or assisting in the provision of legally protected healthcare activity. So this was the combining of those two subdivisions in a way that hopefully reads a little clearer and has that that language that both OPR and the Board of Medical Practice was looking for, which is that it's based solely on, they don't want to be prohibited from denying someone a license who has a criminal conviction that was maybe based in part on legally protected activities, but part on something else. Are there any questions on that section?
So far, so good.
Just need to read it. Yeah.
You're in luck because the next section has identical language. So let me go through that also.
Okay.
So section 7, this is unprofessional conduct. These are regulations related to healthcare providers that are regulated by the Board of Medical Practice. Notwithstanding any other law to the contrary, no healthcare provider shall be subject to professional disciplinary action by the board, nor shall the board take adverse action on an application for certification, registration, or licensure of a qualified healthcare provider based solely on, 1, the healthcare provider providing or assisting in the provision of legally protected healthcare activity, or 2, a criminal or civil action or disciplinary action against the healthcare provider by a licensing board of another state based solely on the provider providing or assisting in the provision of legally protected healthcare activity. You'll see the language that I have stricken through that was previously in subdivision 2. I moved that up into the first paragraph.
Yeah.
So it mirrors that same language. I just condensed it up above and then more clearly specified the basis for when those healthcare providers cannot be disciplined. So as I said, I have not heard back from OPR and Board of Medical Practice about whether this works. So this might be one to circle back to once we've heard back.
So essentially, it would mean in both cases that they can't take action against a healthcare provider or just the act of providing the care. Right. They could take action if in providing that care or some other care, the healthcare provider did something
Egregious.
right, illegal or egregious or something. So
These sections use the term legally protected healthcare activity, which is which you'll see it does have the definitions. We're citing directly to the same meaning as in Title I VSA Section 150 on page 12. So going back to that definition that we covered at the beginning, there's a carve out for activity that would not be legal if it were conducted in this state. So
Unprofessional
those are the
conduct is
instances,
unprofessional.
yes, where if you were to have been disciplined here in Vermont anyway, that's not legally protected health care.
Right,
So combining the two, I think it covers those
okay,
situations.
okay.
Thanks.
All right.
Next section, moving over to pregnancy centers. I will say we had one request or one suggestion in written testimony from the Office of Professional Regulation about what could add in here. That is the only change that's been made in here since the committee just heard testimony midweek this week. So we haven't had a chance, I haven't had a chance to get direction other than what was in written testimony. So I have added that section there, but I don't know if you want to have a larger discussion today or on Tuesday about this section, or if I could just go over
Let's
this
wait until we
language.
get OPR and AG. Well, we've had some testimony.
Yes,
Let's just,
see what's in here.
let's look at what you have here for changes. Then we should open up a little bit of a discussion. There might be some ideas for improvement to this section based on what we have heard.
Yes,
And I know that I have some suggestions and I think others may as well.
so section 8, there are no changes to the definition section. And now I'm scrolling all the way down to page 14. No changes to what was currently in subsection A under unfair or deceptive acts. But there is a new subsection B, which states the medical director of a pregnancy services center or the individual charged with supervising healthcare services provided by the center staff or volunteers at a pregnancy services center shall be responsible legally and professionally for the activities of staff and volunteers performing duties for and on behalf of the pregnancy services center. The medical director or individual shall ensure that the staff of the pregnancy services center, including the medical director or individual, and any volunteers providing healthcare services maintain a level of supervision, training, and practice consistent with legal requirements established under Vermont law, including those set forth in Title 26 and professional standards of practice.
Okay, so can you tell us what Title 26 provides for oversight of the medical director and the center?
So Title 26 is our professions and occupations title. So this has all of the regulatory language for licensed, certified, and registered healthcare professionals. So it would really, where you're looking in Title 6 depends on what type of healthcare professional is working at the center. So a medical director could be, I don't know who a medical director could be, to be honest, which professions it might fall under. So this leaves it open to
Could be a DO, could be an MD.
if they are a licensed, registered, or certified healthcare provider, and they're acting as a medical director or the individual overseeing the healthcare services provided by a pregnancy services center, then this says they need to make sure that everyone is complying, both themselves and anyone else who's a licensed healthcare provider is following those.
And so if there
requirements.
is someone who's doing sonograms, right? Then, and interpreting those, then they would be overseen by OPR and professional board, if it's an MD or MD, looking at the results. So are there requirements in Title 26 or other places that allow for inspection of the facilities or a review of the activities, or is it only complaint driven?
Title 26 is really the regulatory framework for how licensees should be conducting themselves, what constitutes unprofessional conduct, for example, as well as all of the requirements for licensure and renewing licenses. I wouldn't say that it has sections that I'm aware of that are investigatory in nature, other than the boards and the director having the authority to investigate claims of misconduct.
So it is more complaint driven. And then, so the other piece of this is so if we're getting to unfair, deceptive practices or putting out information in pamphlets or other form that might be deceptive, there is no, where is the oversight of that, if any? Or is that also complaint driven?
Where is the oversight? So as this is currently structured, subsection A has the unfair and deceptive act and practice related to disseminating or causing to be disseminated to the public any advertising about the services or proposed services performed at that center. If the management of the center knows or by the exercise of reasonable care ought to know is untrue or clearly designed to mislead the public about the nature of the services provided. As this is written, subsection C gives the Attorney General or the state's attorney the authority to conduct investigations and bring civil actions as a consumer protection aspect.
And so I'm gonna have Senator Hardy have you ask your question, but we do have the Attorney General coming in next week, and so we'll, and OPR. So we'll come back to this section, but go ahead, Senator Hardy, with questions too.
Yeah, I am wondering, I do know that OPR does have some oversight over facilities of some certain providers. We talked about this in the context of massage therapy and other, having registration of a facility. And then they have inspection duties related to some kinds of facilities. And I'm assuming that healthcare clinics have oversight and inspection and things like that. I know for sure that the Planned Parenthood facilities are heavily regulated and inspected. I worked for them and took part in their audits. So I'm wondering if there's a way to include similar types of requirements for the facilities themselves that are clearly providing and have testified to providing medical care at their facilities. And so if there's a way we could get it that way, if other medical facilities are required to be regulated and inspected, then these quote unquote medical facilities should be too. So that's one angle. And then the other suggestion was to look back at some of the work that we did related to the bill we did a couple of years ago, Senator Lyons, about genetic, what was it?
Stem cell.
Thank you. And some of the provisions that we put in there related to notification in the waiting rooms and in the exam rooms.
FDA approved.
Yeah, for stem cell treatment should be a similar tactic we could use here.
So what I'm going to suggest is we let OPR, when OPR comes in and AG come in, we can ask some of the questions that we have regarding oversight. Because I think then we'll be able to move forward a little bit. But and unless Amber, you can answer all the questions about facilities oversight.
Not right at the moment, I cannot.
Okay, I think, yes, and I'm not wanting to put you on the spot, but there are several questions here, and we do need to hear from OPR and others.
It's not a question, but I just want to agree with Senator Hardy. I think that's a great idea. Facilities, if they're going to be doing any kind of medical treatment, then they need to be under the same scrutiny.
Yeah, no, that was my question, and we get to it here with Title 26, but I think there may be some more elaboration that we want to add in here because it is such a concern. So we'll just have to hear from OPR, we'll hear from AG, and then we'll see what works.
Yes, ma'am, thank you. Just curious if this unfair and deceptive act subsection B is brought over from the House bill? Is that kind of the genesis of this?
Yeah, well, the bill is introduced.
The subsection B language suggested by the Office of Professional Regulation, which I have tweaked some terminology wise, but if you go back and look at OPR's written testimony, you can see it in there.
I thought you were asking about the other one. No, so OPR has weighed in. We will hear from them again, and we have our own questions that we need answered. Okay.
Right. Moving into the next section, section 9 reports. I have this flagged in gray. You heard testimony from both the Department of Health and the Green Mountain Care Board sort of about the difficulties maybe of doing this work as it's written. So I did have a follow-up call with the Green Mountain Care Board to learn more about what types of information they would need from you to be able to do this type of work. And then there was some discussion about whether what they can do will get to the issue that you are looking to address. So reading this section, and I will say this is one of those sections that was based on the Massachusetts legislation, seems to be looking at identifying areas where people do not have access to abortion or birth care or gender affirming healthcare services within a 50-mile radius. So one of the issues with this, as you know, is that there's telehealth, and then there's also things like medication that can be sent through the mail. So in speaking with the Green Mountain Care Board, it became clear that while they can find from their claims database where providers are located, that does not necessarily get at where patients are receiving services or where patients are seeking services but are not able to get the services because Green Mountain Care Board only actually sees the claims once services have been received.
And so my conversation with the Green Mountain Care Board, we did talk about the HVAC, but also about the needs assessment.
I'm trying to get on to be prepared, I was being all sly about it over here.
So HRAP and Act 167, and there may be some value in having, they were supposed to get back to us, so I'm leaving that in your hands.
Okay, I will say that the HRAP, the Health Resources Allocation Plan, that the Green Mountain Care Board is responsible for conducting, which is, for those of you who don't know, sort of a survey of where services are within the state under different types of categories. That is based on the data, the claims data for the most part, as well as any other data they receive from other agencies. So it is in the same way facing the same sort of limited problem,
yeah,
as if they were to try it outside of HRAP. So I think it would be helpful for me in going back to them or going to anyone else that you would like to hear what are you hoping to learn from this report? And then we can figure out where we can get that information and who could provide that information.
Yeah, I think there's an interest in understanding where there are OBGYN clinics and other and clinics available for reproductive health care services. Green Mountain Care Board obviously isn't the only place we can get that. Probably AHS can help us with that. And perhaps we can send a line out to VMS to help with that. But we would like to know that we have coverage for people who require these services.
Yeah, I would just add that especially for gender affirming care, there's really not too much, and especially the rural parts of the state. I do think we need to be really careful about how the data is reported and how providers are identified. I would rather not have it be specific to this is where the clinics are and this is where the doctors are, but really more broadly about access and
Where the needs
these are places in the state that we have gaps in service or gaps in care.
Yes.
You know what I mean? More generally than specifically. I don't want to put any providers at risk by having them identified. But I also want patients to be able to know where they can go to get care or where they don't have care, especially in relationship to the sort of higher ed section, which we haven't gotten to. We have rural college campuses that may not have access to care very directly, especially, and that's just an age group that uses these services more.
I think this is why the needs assessment is the place that, going forward, the needs assessment in Act 167 will be identifying gaps in care or redundancy. So
Yeah,
that piece, and that is joint work by AHS and Green Mountain Care Board. So maybe there's a different wording that we need here. And I know the Green Mountain Care Board was very concerned about having confidential information released in the way that Senator Hardy has mentioned, and also patient information. So it's delicate.
Thank you. That is helpful.
Senator,
I've got a constituent who is obviously watching.
sure.
And they want to know, is there any way that we can get the statistics of how many gender affirming treatments and abortions have been conducted in the state?
The Department of Health has that information on its webpage, has abortion care services disaggregated, so it's not by individual. And gender affirming care, I don't know if it's on their webpage or not on their dashboard. But certainly we can ask, there are very limited services in the state concentrated in one area. We can ask what the numbers look like, and we can reach out for that. I'm not, I'm not sure. You can do that. We can do that. Yeah.
I think it's important to understand that gender affirming care, unlike an abortion, which is a single sort of, procedure, gender affirming care encompasses a wide variety of things, and it can be with hormone therapy, mental health care, surgery for adults, and a wide variety of things that are encompassed under gender affirming care. So it's not an easy thing to do a sort of report on.
So they've also asked, if, do we have any anticipation of how many these type treatments or procedures are going to be
They're not procedures. It's a broad
Okay.
amount of primary care that includes mental health care, that includes pediatric care, that includes primary care, that can in some instances include surgical care, and it can include hormone therapy. There are a whole host of things. So having an individual report about how many services are provided is really just not possible.
So I'll take that as a no.
Yeah, I mean, I think
It's tough.
it's really,
So-
and the abortion stats, as Senator Lyons said, are easily accessible and have been for a very long time on the Department of Health website.
So, and I will say that, that right now, there is a wait list for pediatric wait list for the initial stages of care for people with kids, adolescents with a need for gender affirming care and interest in understanding who they are. So that we don't know. The number that I've seen on that wait list is close to 100. But I don't know, and that becomes you dive into some confidential areas because we have such limited care in the state. That's what it is. Okay.
Next section. This is the last of my sections.
Okay. Good. I mean, not good. We're gonna miss you, but
Thank
I know we're giving you a lot. We're giving you a lot of work.
So this next section is the second report section. This is concerning the Board of Medical Practice and the Office of Professional Regulation concerning the interstate compacts. I did not make any changes to this section, as did not seem to be any concerns, for the most part, from the Board of Medical Practice and the Office of Professional Regulation around this section. I will say that rereading this language now, having given it a little more thought, I think I might, so the report would be with that the Board of Medical Practice, in consultation with OPR, shall submit a report to the House Committee on Healthcare and the Senate Committee on Health and Welfare with findings and recommendations for legislative action to address any concerns regarding the state's participation in interstate licensure compacts as a result of the provisions of this act. I have said specifically in here in the original language, and I think I would change that to including at this point, because the legislature is reviewing so many compacts this year and possibly next year. And I know at least the counseling compact would have, because counseling services are a part of gender affirming care, that we want to be cognizant of what compacts we are getting into and how they will affect this. And I think having a report back will allow you to hear from OPR and the Board of Medical Practice, both on how things are going with the current compacts, as well as if they see any other compacts that are on the horizon that they want to flag either as something that Vermont should not be entering or could be entering, but maybe we should wait until there's some sort of rule adjustment or something that would allow the laws in this act to coincide with those compacts without conflict.
Yes, no, I think that's, the point you've made is really appropriate. And the testimony that we heard from the interstate compact folks was somewhat concerning. Go ahead.
Thank you, Senator Lyons. I guess I would also add, it says recommendations for legislative action. And I think I would add, I don't know who the appropriate authority is, whether it's Board of Medical Practice or whomever is the legal holder of the compact for Vermont, because I think one of the actions could be that the state of Vermont puts in a request for some kind of action on the compact. I don't know exactly how that's
It's
done,
a
but
representative to the compact shall make a recommendation regarding, and then from there we put, because that was a comment, a suggestion I was going to make as well. So first, we need to include all the compacts somehow. We want to get a report back, but I think we really do want to have language that directs our compact representatives to make a recommendation about reproductive care or
yeah, it was very clear
professional something.
From their testimony that they were taking a kind of hands-off, we're going to please everybody kind of approach. And I think that Vermont and states like ours need to be being assertive about, you need to follow
Medical care.
the standards of care for
Standards of care.
for each medical specialty, and they're clearly allowing states to say, oh, we don't want them to practice medicine without following the standards of care,
Right.
which shouldn't be what a medical compact does.
Exactly.
And I think Vermont needs to take a more proactive, assertive stand and say, this is not okay. And this is not what medical practice.
So let's see if we can get a statement in about that for the two that are in place. And then for any future compacts. And then as this committee and other committees looks at compacts, this is something we might want to reinforce, because I know we're getting them. They're coming over to us.
Yeah.
Whole passel of them. And we've got Senator Hardy's committee will be looking at these, and our committee will be looking at these. Okay. You're out of it now, education. You don't have to look at those. Okay, so does that make sense?
Yes.
All right, thank you. So the flags that we put up, so any connections that you can make, we've asked our insurance folks to work with you. We want to modify some of that so it's more, not all. not too explicit in statute, enough to be consistent. And then I think that's the toughest one. And then there's a couple other flags. So we'll get OPR and AG in, that'll help clarify. Let's just go through the flags briefly, so we know what we have. I'm gonna go through the ones that I have. So, we're gonna consider the word secured on page 2. And how we can get maybe a better word. And on page 6, we have a flag up around the abusive litigation issue. On page 7, we have the question about medically necessary and how that fits in. It is a health insurance section, so maybe it does. But then we also want to reach out to Dr. Gibson and maybe Jessica Barnard on that section. On page 8, we have MVP, DEVA, Gibson, Blue Cross and Blue Shield, looking at B for commercial insurance plans. On page 9, I think we're okay. There was a half a question.
I was going to look into something
You're
on
gonna
page
look
9,
at
yes.
that, yeah, and then on page on the whole, we're sort of waiting for OPR and AG, but we're gonna think about the regulatory framework for the crisis pregnancy centers and how that fits. And that's on page
14, 15.
14 and 15, and then on page 15, we're looking at the reports. We have the ATRAP Act 167, AHS, Pre-Mountain Care Board question, and then on is that it? Does that end you? And then we have the interstate compact where we're going to get some language. That's it for you.
Yes.
Okay, this is good. Go ahead.
Just one question. Section 9, looks like it's highlighted. Is there?
Section 9, that was the report from the Department of Health and Green Mountain Care Board that I knew we needed to make some changes, but I wanted to hear a bit more from the committee about where they wanted to go. So I have direction on that one now. So you can assume that that will be different the next time you see it.
Okay.
Thank you.
You're welcome.
Great, thanks. This is a lot. This is heavy duty. It's hard to plow through all of this. So when we come back to it, hopefully we can have another opportunity to hopefully finalize it in some way. So we're moving on to the next section with Jen Harvey. Do you want a little break? Can we take, Jen, we're gonna take a 5-minute. Let's do that and we'll come